Let me make sure. Hello, Mr. Sheriff. Do you have access to Mr. Nelson?
Yes, ma'am.
Thank you. Hi, are you Zachary Nelson?
Yes, ma'am.
Okay, be sure and speak loudly enough so that we can all hear you. Lean in towards the microphone, towards the computer, okay?
Yes, ma'am.
All right. Turn you around. Do you see your lawyer in the courtroom? Ms. Hathaway, can you see her?
Yes, ma'am.
Okay. Okay.
Court will now call case number 1231, the State of Texas versus Zachary Tyler Nelson. Sir, for the record, are you Zachary Tyler Nelson?
Yes, ma'am.
All right. This is a motion to reinstate bond filed by Ms. Hathaway. Ms. Hathaway, are you ready to proceed?
I'm ready, Your Honor.
And is the state ready to proceed?
State's ready.
All right, Ms. Hathaway, it's your motion. I'll ask you to call your first witness.
Thank you, Your Honor. I call that. Mr. Nelson, would you please raise your right hand? Raise your right hand and be sworn as a witness. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
Okay, you can put your hand down. Please state your full name
Excuse me?
and your gun.
Yes, you may. You can come stand right up here.
Please state your full name.
Zachary Tyler Nelson.
And that's ZACHARYTYLERNELSON, is that correct?
Yes, ma'am.
And Mr. Nelson, you understand that you have been charged with some very serious offenses, correct?
Yes, ma'am.
It is alleged that you used a firearm to severely injure another individual, correct?
Yes, ma'am.
So you have an aggravated assault with a deadly weapon charge pending, correct?
Yes.
It is alleged that you committed burglary of a habitation with intent to commit a felony offense, a first-degree felony. You understand that?
Yes, ma'am.
And you understand that these are very serious charges, correct?
Yes, ma'am.
And we're here today to ask the court to reinstate your bond. Do you understand that?
Yes, ma'am.
Anytime we have a bond hearing, the court needs to make a determination as to whether or not you're a flight risk, the serious nature of the offense and how it relates to giving a bond, and whether or not there is any type of assurance that you are going to be returning to court. You understand that?
Yes, ma'am.
Mr. Nelson, where do you currently reside?
2301 East 16th Street in Dalhart, Texas, Lot 2.
Okay. And how long have you lived in Dalhart?
Since January of this year.
Okay. Where did you live before that?
In Stratford, Texas.
Okay. How long did you live in Stratford?
Approximately 10 years.
And this offense is alleged to have been committed in Stratford. Is that correct?
Yes, ma'am.
Okay. Now that you are living in Dalhart, are you currently, or were you employed prior to getting placed back into jail?
Yes, ma'am.
And with whom do you work?
Johnson Welding.
How long have you been working for Johnson Welding?
Roughly 15 years.
Okay. Now, as a part of your bond, you were assessed an ankle monitor. Is that true?
Yes, ma'am.
And Mr. Nelson, if you could tell the court real quick, how much is your bond, if you recall?
I believe it was on two of the counts, it was $18,000, and one of them it was $12,000.
I'm not asking how much you're paying to the bonding company. I'm asking how much your bonds are in total. If you're aware.
I think it was two $18,000 bonds and one $12,000 bond.
Okay. There is a motion that was filed by the state to increase your bonds and modify conditions that was filed in this case on the 7th day of January of 2023, where your bond was increased to $60,000. Do you recall that?
Yes, ma'am. Yes, ma'am.
And that was for the offenses of burglary of a habitation, ag assault with a deadly weapon, tampering with evidence, and deadly conduct by discharging a firearm that occurred in Sherman County, correct?
Yes, ma'am.
Your Honor, at this time, I would ask the court to take judicial notice of the filings in reference to the bonds in this case.
Ms. Hathaway, when was I see the present motion to reinstate bonds.
Mm-hmm.
I'm looking, what date was the motion to modify filed?
I received it the 11th of January of 2020. Well, I have it here as the certificate of service going to his prior attorney on the 11th day of January of 2023.
The case I have was indicted on June of 2023.
This was an offense that he was arrested for it in January, and then the state filed a motion to increase post-indictment. Well, actually, that was post-arrest on this charge, and then it was indicted in June.
I see. So none of those, nothing pre-indictment is in the court's record.
If I may, Your Honor, I have a copy
That would be helpful.
of the motion.
Thank you. Right, the court will take judicial notice of a motion to increase bond and modify conditions that was filed in January of 2023. Correct?
Yes, ma'am.
All right.
After that motion was filed, your bond was increased, is that correct?
Yes, ma'am.
And you were ordered to obtain an ankle monitor, is that correct?
Yes, ma'am.
When you obtained the ankle monitor, did you go in and have a meeting with whoever supervises the device?
Yes, ma'am.
And you're required to pay a monthly fee for having that device, correct?
Yes, ma'am.
And what is that monthly fee?
$250 a month
Okay, and you've been paying that since July, is that correct?
since
Or,
July.
I'm
Yeah.
sorry, since January?
No, the ankle monitor was placed on me on July 24th of this year, and I've paid since then. So I had a payment in August and a payment in September.
What were the terms and conditions that were placed on that monitor?
I was to go to work and straight home, and then only able to go to Dumas, to their facility, the management, the ankle monitor place. And then I was also granted permission one time to go to your office in Amarillo.
Were there provisions put in place for you to go to the grocery store?
No, ma'am.
Were there provisions put in place for you to get gas so that you could go to and from work?
Well, I spoke to the officers. I asked him, and he said, obviously,
Nope. If you will answer my questions, please.
okay.
Was there a provision put in place for you to get gas to go to and from work?
No, ma'am.
Was there a provision for any type of emergency that may have occurred? Was there any type of protocol put in place for that?
No, ma'am.
Were there any provisions for you being able to get food or not get food while you're at work?
No, ma'am.
Now, it's true, is it not, Mr. Nelson, that your work requires you to travel?
Yes, ma'am.
You're not always in one place, correct?
Never in one place.
It was made very clear that you are to have no contact with the victim and stay away from where the victim resides, correct?
Yes, ma'am.
And you no longer travel to Stratford, is that correct?
Yes, ma'am. I haven't been to Stratford one time.
Okay, and in fact, the state has brought to court today and will provide a list of violations that they allege that you committed while on this ankle monitor. Is that correct?
Yes, ma'am.
919, it alleges that you went to Wendy's, correct?
Yes, ma'am.
918, Toot and Totem, is that correct?
Yes, ma'am.
916 to the 1800 block of 13th Street in Dalhart, is that correct?
Yes, ma'am.
Can you tell the judge who resides there?
Can you tell the address again? It was,
The 1800 block of 13th Street in Dalhart, Texas,
that's Alan Womble, the owner and my boss of the
and
business.
that's your boss, correct?
Yes, ma'am.
And you went there for work, correct?
Yes, ma'am.
And then again, Wendy's on that day, is that correct?
Yes, ma'am. I believe that Wendy's, I was getting gas.
I didn't ask that, if you'll just answer my questions.
Yes, sorry.
Not trying to be curt, but the judge has a full schedule, so we need to be efficient. You are also alleged to have gone to Toot and Totem on 913, is that correct?
Yes, ma'am.
On 912, you're alleged to have gone to the 100 block of Peters in Dalhart, is that correct?
Yes, ma'am.
Who lives at that address?
Our secretary for the company.
As part of your employment, are you required to take documents billing over there for her to then send out?
Yes, ma'am.
Okay. So all of your violations are either involving going to see the secretary, your boss, or get food, is that correct? Or gas?
Yes, ma'am.
Now, you are also required to pay with a money order to the GPS people, is that correct?
Yes, ma'am.
Did they provide a way for you to get those money orders?
No, ma'am.
Have you emailed them to request to be able to go to the post office?
Yes, ma'am.
Have you also made requests about being able to do other things that you need to do, like getting gas or getting money orders?
Yes, ma'am.
Have you received any response?
One time I did, and all the rest of the times, no.
Okay. You would agree with me, Mr. Nelson, that you need to be able to eat, correct?
Yes, ma'am.
You need to be able to do normal things while you're out on bond, like going to get your check from the mail, correct?
Yes, ma'am.
You need to be able to get gas for work.
Yes, ma'am.
You need to be able to confer with your attorney and do things that your attorney asks you to do as well. Is that correct?
Yes, ma'am.
Okay. You're not denying that any of these violations occurred, correct?
No, ma'am.
Okay. Now, were you led to believe that you could go, as long as you were in and out quickly, to get food?
Yes, ma'am.
Okay. And your boss was with you when you had that conversation at the GPS place. Is that correct?
Yes, ma'am. Because I had forgot my charger in the place, and he come outside and spoke to us at the pickup. Yes, ma'am.
Okay. And your boss was present for that conversation. Is that correct?
Yes, ma'am.
Okay. Other than that, you yourself are putting up the money for this bond, true?
Yes, ma'am.
You have a home in Dalhart, correct?
It's an RV, but yes.
Okay. Do you have property in any other state?
No, ma'am.
Okay. And I'm asking you that because, again, the court needs to determine whether or not you're a flight risk. You understand that?
Yes, ma'am.
Okay. You understand that if the judge reinstates your bond, she may continue to do so with conditions, and you will have to follow any of those conditions. You understand that, correct?
Yes, ma'am.
Thank you. Pass the witness.
You may, and if you will excuse me for just a minute. I'll be right back.
Take an antibiotic. She has a really badly abscessed tooth. Bad, and she needs surgery. But we don't have time, so she's got to put it off till the 24th. And so they put her on heavy antibiotics. Please proceed, Mr. Cook.
Sir, my name's Colin Cook. I'm a prosecutor for the state of Texas. I'm going to ask some questions. If you need me to repeat or rephrase, just let me know, okay?
Okay.
So your attorney covered a lot of stuff with you, but all the things that she says you did, those were not allowed in the order set in your GPS, right?
Yes, sir.
So going to go get food was not allowed, right?
Yes, sir.
Going to your boss's house, I mean, was that for work or were you just going to his house?
That was actually one of the things that they did respond back to me on. I asked them, I told them that most often we have lunch over at his house and kind of go through our day. And they said that that would be fine. And then I messaged back if they'd like me to send them the address, and they never replied and said that. So, and he has materials at his house.
So
Go
it's your testimony today that they allowed you to go to your boss's house, but you never provided the address to them?
I asked them if they wanted it, and they said they didn't need it.
I also heard, I think it's your testimony today that they said you can go get food if it's a quick in and out, right?
Yes, sir.
Okay, do you remember what date that you got that permission?
That would have been the day it was placed on. So I believe that was July 24th, 2023.
Okay. Did you meet with Mr. Tommy Brooks?
There was two. It was. I've seen two of them. It was. I don't know really how to. I didn't catch both of their names. It was one of them.
Okay. So the two gentlemen in the emergency management office that were both present there then?
Only one was. They were there other times, but it was the one that where's the cowboy hat? I'm not sure which one that was.
Okay. But regardless, I mean, they went over the order with you, didn't they?
Yes, sir.
Okay. And so in the order, it doesn't say you're allowed to do any of the things that they have on these violations, right?
No, sir.
Okay. So when you went to Juan's windshield repair, that wasn't allowed?
That's work. I was paying for a windshield for one of the pickups at work.
Okay. When you went to Triple T Meats in Sunray, was that allowed?
I didn't go to a Triple T Meats. There was a food trailer in the parking lot.
Okay. Let me ask you this. Do you live with anyone?
No, sir.
Do you have family in Dalhart?
No, sir.
Do you have friends in Dalhart?
Yes, sir.
Okay. So if you really wanted to comply with the court's order, you could get someone to bring you groceries at home, right?
Yes, sir.
Okay. So you could get someone to do all the errands that they're saying you must do. You at least have somebody who could help you out. Isn't that right?
Yes, sir. I mean, that's a lot to ask of other people.
Okay. But I mean, if you're court ordered not to do these things, then you might as well ask before you do them yourself. Wouldn't you agree with me?
Yes, sir.
That's the witness judge.
I have no further questions at this time, Your Honor.
All right, Mr. Nelson, you're excused as a witness, and I will ask Ms. Hathaway to call her next witness.
Are you Alan Womble?
Yes, ma'am.
Mr. Womble, I'll ask you to raise your right hand. I'm going to swear you as a witness. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Ma'am.
Okay, you can put your hand down. Do you see Ms. Hathaway here? Okay.
I can see y'all.
Okay.
Okay, your name is Alan Womble, is that correct?
Yes, ma'am.
How do you know Zachary Nelson?
And worked for us for,
And who is us?
Johnson Welding. Wally Johnson, I actually just bought the business, so I haven't had it since about August, but Wally, my father-in-law, was the boss, and then I took over in August.
And you understand that Mr. Nelson has some pretty serious pending charges, correct?
Yes, ma'am.
You understand that as part of his pending charges, he was required to get an ankle monitor, correct?
Yes.
And did you go with him when he got the ankle monitor put on? Do you recall a conversation that was had between he and one of the personnel monitoring him about whether or not he could go get food while he was working or during the day?
Yes, I was there when he got the ankle monitor.
Okay. And was he given a go-ahead to be able to go get food from the gentleman that got him the ankle monitor?
I understood, and what we were told was that if he got something to make it quick, and he couldn't go to the grocery store.
Okay.
That's what we were told.
So you were with him when this conversation occurred, correct?
Now, what actually happened is when we went to pick up the ankle monitor, we actually forgot the battery. So the officer came out and, like, hey, here's your battery. And then we asked him then, and that's what he told us. He's like, if you're going to go somewhere, make it quick on eating, and that he could not go to the grocery store.
Now,
And then anything for work, I thought that it was, fine for him to do anything for work. That's sure what we understood.
okay. Now, can you please tell me who lives on the 1100 block of Peters?
Yes, that's my son and my daughter-in-law, and that actually since August, I don't have an office, so that's where our office is. And of course, Tristan, my other son, he works for me too.
Okay.
And that's where he picks them up and we get our paychecks and everything over there.
What about the 1800 block of 13th?
That's my house, and he also told us, because we eat lunch over here all the time, and we asked, and, because we're over at my house all the time too, for lunch anyway, and sometimes in the morning, and I've got a lot of material over here that I have stored for us that, we have to come over and get. So, from our understanding, we were told, my house was definitely okay. And then, with Tristan and Callie's house, we've moved our office over there, and that's where our office still is right now, over at their house. Callie works out of her house, and we pick up our paychecks and, anything else that we need. And the bad deal is I've been sending back there thinking we were okay.
Okay. And does he have occasion to go to different places to do things for your work?
Yes, another thing is we've been working right over there by the cow feed. That's right in the middle of Delhart. It's just, right across from Sonic and Allsups. And, we work in town. I work in all over. We'll be in Hartley. We'll be over there in Dumas, Eder, Cactus, Sunray. I've got jobs all over the country.
And are you holding Zachary's job for him, at least for now?
Yes. Yeah, Zach's a big, vital part of my business. I just took this over, and he's my foreman. So, I've got him running everywhere. for work, and it's all over. Like I said, Sunrise, Cactus, Hartley, Janning, in between Janning and Hartley. We're working out Nortex feedlot. There's times that we can go to Tex Line.
Sure.
There's times when we're working town. We got, just lots of places that we've been going.
Yes, sir. And Mr. Womble, given that you've known him for 15 years, do you think that Zachary is a flight risk?
No means do I think that's a flight risk.
Okay. Have you ever known him to leave Dalhart or Stratford, his place where he stays or when he works with you, unaccounted for long periods of time?
Never. That kid's always, at work. Even that's really all we ever do is work. Sundown.
Yes, sir. Thank you, Mr. Womble.
He's always responsible. He's extremely good help, and he's sure a vital person to my business.
Thank you, Mr. Womble. I pass the witness.
Mr. Cook, do you have any questions?
Just a couple, Judge. Thank you. Hey, Mr. Womble, I don't know if you could stand a little bit taller, so I'm gonna move back.
I can see you.
Okay. My name's Cullen Cook. I'm a prosecutor for the state of Texas. I'm going to ask you a couple questions. If you need me to repeat or rephrase, just let me know, okay? How long has Mr. Nelson been working for you, sir?
About 15, 16 years.
Okay. So you're aware of his prior criminal history, right?
You're talking way back in early 2000s?
Early to close to 2010, yep.
Yeah, we kind of knew a little bit about that.
Okay, so you know about his assaultive history?
Well, yeah, he kind of been out of trouble with us, I think he was in a little bit of trouble for a year or two when he first started, but after that, he had never been in trouble.
Okay. Let me go ahead and ask you, how many people do you have working for you?
Well, right now, I've got 1, 2, 4. There's 5 counting me, and then I actually, since I lost Zach, I brought in 4 more guys that I had to hire out. So I've got 4 guys that, I brought in these last couple of weeks to help us out.
Okay. And so whenever you talk to your employees at your home, you said you guys eat lunch. How long does that typically last?
Lunch.
Yeah, I believe you said you guys meet at your house to have lunch and talk about the day.
Yeah, sometimes in the morning we'll be here and gather, for 30 minutes to an hour, and then if we got, I got material over here, so if we're having to load anything, it could be a little longer, and then, usually lunch is, around an hour or so, if we're around.
Okay. And so whenever you had that conversation with emergency management when you went with Zach there, what were the exact words that they said he could do outside of the court order?
What I understood, he could come to anywhere that involved work. And that's what we really try to do, is base it on anything that was for work. And then he did say that if Zach was to get something, like at a fast food restaurant, just to make it quick. He didn't act like he could go in or anything, and then, a lot of times that Tooth Totem and all them, we're just getting gas and stuff, for our welders and for our pickups.
Okay, when does your workday typically end?
Well, typically around, 6:30, and Zach really had to be in by 6:30, but then we called and asked because I was needing to work later. I've got lots of work and I'm super behind. So, he said if it was for work that, he would know where he was and it would be okay, but, we do work. I don't know if he just went out there at the Jerry's, but, I bought this crane in August and work's really boomed for us. So, you know, I'm getting work in town, out of town, and, you know, we're having to go a lot of different places.
Okay, would you be willing to help Mr. Nelson procure groceries or buy him food without him having to go to those places if his bond was reinstated?
Yes, sir, we will. We did not want to do anything wrong the first time, you know. We had went in like the day before to pay his bond, and no one even said nothing to us, you know, like, hey, you've been in the wrong spot. Hey, you know, we didn't have any kind of coaching whatsoever, you know, other than what he had told us that first day. And of course, you know, they went over there several times to make his payment for his ankle monitor. And we had, the night he got arrested, he had just went over there and paid that like the day before. You know, we weren't said nothing like, hey, this is looking out of the ordinary, you know, this is not where we're supposed to be, because we would have corrected that. We sure don't want, we did not, and I know Zach felt the same way. He did not want to, you know, get back in trouble.
Okay, thank you, Mr. Womble. Pass the witness, Judge.
Anything further, Ms. Hathaway?
I have no further questions for Mr. Rumble.
Okay, thank you, Mr. Womble. You may be excused.
Okay, thank you. Now all good?
Yes, if you need to leave, you can hang up.
Okay, well, thank you guys, I appreciate you.
Thank you. Right. Mr. Cook, do you have any witnesses?
Yes, sir. Judge call Tommy Brooks.
Tommy,
Yes, ma'am.
if you'd raise your right hand, please raise your right hand and be sworn. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God?
Yes, ma'am.
Hey, Tommy, good to see you.
You as well, sir.
We're here on Zachary Nelson. Are you aware of this individual?
Yes, sir.
Do you see this individual on the screen today?
Yes, sir.
Are you in charge of monitoring GPS for clients that are ordered to wear a ankle device monitor from the court?
Yes, sir.
Can you kind of explain to the court how that process starts once they get to your office?
When they come into the office, we go over the rules, regulations, we go over their court orders. We go over how the device operates, how to charge it, emergency situations, and then we install the device and release them back to the jail or bondsman.
Okay, and whenever you're going over rules and regulations as opposed to the order itself, I mean, what kind of rules and regulations do you describe to the client?
They can't submerge the device in water. They must charge it 2 hours a day. They have to pay their monthly fees. Things of that nature.
And Tommy, how do you decide where a client is allowed to go?
I don't decide that. The court decides that.
Okay, and how do you know what the court has decided?
It's in the court order that the judge issues.
Okay, so outside of the court order, do you give permission to clients to do anything that's not listed in that order?
No, sir.
Does anybody that works for you give people permission to do things outside of that order?
They should not, no.
Okay, so there's been testimony today that whenever Mr. Nelson came into your office to discuss the device, that he was told he was allowed to go get food, if albeit quickly, if he needed to. Does that sound like something that you or one of your employees might say?
No, sir, that is not our normal routine.
Okay, so just, in your personal opinion, how do you expect people to eat if it's not in a court order?
There's options out there, DoorDash, Walmart delivery, friends, family.
If someone has friends or family, is that a viable option for to stay compliant with the court order?
Absolutely. I mean, I'm depending on the court, most of them, yes.
Okay,
There
and
is some, certain family members can't be around or non-blood related relatives.
so with respect to Mr. Nelson's specific case, what do you know his employment to be?
He's a welder, I believe, that goes numerous different locations.
Okay, so would it be fair to say that he travels for work?
Yes, sir.
Okay, and how do you handle that whenever someone's on a GPS monitor?
It's very difficult to monitor them people because they're not locked down on the GPS. So we just have to review it on a daily basis, the travels from the day before.
Okay, and so whenever you're reviewing, are you looking at a computer screen?
Yes, sir.
Can you kind of describe to the court what that looks like?
It's a map with a bunch of green dots on it, shows their location throughout the day.
And are those dots directional?
Yes, sir.
In this case, how many violations did you note that Mr. Nelson had committed?
We done 7 notices of violation, with different violations throughout the day.
Do notices of violation look like this?
Yes, sir.
And Judge, we've stipulated to these being admitted into evidence, so here's a copy for yourself to look at.
State's exhibits
1 through 7.
1 through 7. State's exhibits 1 through 7 are admitted.
So Tommy, there were a couple of residences in there that you weren't sure exactly who they belonged to. There's been testimony today that it belongs to the owner of the business for which Mr. Nelson works for, and I believe a son and daughter-in-law of the owner. That would be the 1100 block and I believe 1800 block that are mentioned as private residences. Do you know anything about that?
No, sir, I was unaware of who they belong to.
Okay, did Mr. Nelson tell you about an address in relation to those residences?
It's possible that had said something about an address, but I didn't have it documented in his file.
Okay. So really, if we look through these notices, some of them are explained away as work-related if we're talking about a gas station, right?
It could be work related, yes, sir.
Getting food during the day, that could be attributed to him going, stopping during his workday to grab a bite to eat, right?
Yes, sir.
Going to these residences, that could be him going to meet his boss or the son or daughter-in-law of the boss, right?
It could be, yes, sir.
But are any of these things allowed in the court order?
The boss's place possibly could be contributed work related. The restaurants or the gas stations or the food places, no, it's not in the court order.
Okay. And in your experience, is this a lot or a little in terms of number of violations?
It's more on the heavy side, yes, sir.
Pass the witness, Judge.
Ms. Hathaway?
Tommy, you certainly could have reached out to my client and asked why he was going to those residences, correct?
I could have, yes, ma'am.
Now, I'm not saying that's your job. It's just you certainly could have said, hey, since I don't have documented and you said something about a residence, whose house are you going to, right?
Yes, ma'am. We could have.
Okay. And that answers my question. Thank you. And in addition to that, any time that we're talking about going in and out, and we had testimony not just from Mr. Nelson, but another person that indicated that the person that ran the device came out and said that he could go eat as long as he made it quick. That's not, if it's not documented, you wouldn't know, correct?
Correct.
So if another person heard that, you're certainly not saying that it didn't happen, correct?
I don't know who said that, no.
Sure. My question is, you're certainly saying that you're not saying that it didn't happen, correct?
No, ma'am, I can't speak to what happened or didn't happen if I'm not aware of the exact situation.
You have an app by which you communicate with clients, is that correct?
Yes, ma'am.
Now, the app has since this violations have been alleged, that app is no longer available for those messages to be reviewed. Is that correct?
I'm not sure. I'd have to look and see if it's still in his history.
Okay. Would you agree with me that Mr. Nelson has messaged many times asking the specifications of things he can or cannot do?
Again, I would have to look back on the history.
Okay, so since you're not aware, you're certainly not saying that he didn't, correct?
Correct.
Thank you. Nothing further.
Anything further, Mr. Cook?
Briefly, Judge. Tommy, you mentioned the court order before, remember that?
Yes, ma'am. Yes, sir.
Outside of the four corners of that document, are you telling them they can or can't do anything?
No, sir. It has to be within that document before we authorize a movement.
Okay, so Mr. Nelson contacting you to see what the rules are, he could just look at that court order, couldn't he?
Yes, sir. Correct.
Thank you, Tommy. Pass the witness, Judge.
No further questions, Your Honor. All right. Thank you, Mr. Brooks. You may be excused.
Thank you, ma'am.
Mr. Cook, any additional witnesses?
Just one, Judge. Brings for a lot.
No, still, yeah. Yeah. Mr. Spurlock, can you unmute yourself, please, sir?
There we
There
are.
you are. Great.
That was quite a
Mr.
wait.
Spurlock, I'll ask you. If you'll raise your right hand and be sworn, please, sir. Do you swear to tell the
Okay.
truth, the whole truth, and nothing but the truth? So help you God?
I do.
Okay, you can put your hand down. I'll turn you around so you can see Mr. Cook.
You may proceed, Mr. Cook.
Thank you, Judge. Hey, Mr. Spurlock, I know we know each other, but could you introduce yourself to the court today?
Yeah, I am Stephen Brent Spurlock.
And Mr. Spurlock, where do you live?
I live in 1210 Northwest First in Stratford, Texas.
And so, did you have an opportunity, and I say opportunity is probably not the best word, but to become involved in an incident that happened in January 2023 of this year?
Yes, sir.
And can you tell the court briefly how you got involved with that?
Okay. Of course, Derek Johnson, he works for me. He had called. It was right at about 4 a.m. I don't even know why it woke me up. I answered the phone. He was in a lot of distress. He, had said he got shot and he was needing help and he was, scared he was dying, going to bleed out.
Mr. Spurlock, how far away, where was he at this time?
Okay. He was at his apartment which he lived in a duplex that I own.
Okay, and so what happened after you received this call?
Of course, I told him, you're just going to have to hold on. I said, did you call 911? And he said, yes. And I said, so I'm getting dressed and I'm talking to him. And so I actually said, I'm going to get off the phone. You got to hang in there, buddy. And, because I wanted to call 911 myself and make sure somebody was on their way. Because, it was worrying me to come to the situation, not only with him being shot, but I don't know what I'm coming up on either. And so I quickly
1 minute, sir. 1 minute. 1 minute, sir.
Ask me to answer the question. Narrative.
That's fair, Judge. I'll break it up into questions.
Thank you.
Mr. Spurlock,
I'd like to make this witness.
Name?
Mr. Spurlock, do you know Zachary Nelson?
I do not.
Do you know whether or not Zachary Nelson is a flight risk?
I would not know that.
Okay. Do you know any of the conditions of Zachary Nelson's bond?
I do not.
Do you know any of the alleged violations that have occurred as a part of his bond or GPS monitoring?
I do not.
Thank you. Your Honor, I understand the importance of putting the serious nature of the offense on, and I believe that you are aware of the offenses and what the allegations are. I understand that, but we're here about a bond, and we're here about the allegations that we have to go through in whether or not the court is going to assess a bond, which are whether or not he is a flight risk, the likelihood he will return to court, and the serious nature of the offense, which you already have before you. If this is going to go on like this, in this format, it only serves to bolster the state's position, and it's not necessary, nor is it relevant to setting a bond. His experience that night is relevant at trial, not in a bond hearing.
Mr. Cook?
his experience is relevant in this bond hearing because it shows that the defendant is a danger to the community and a danger to the victim. As he mentioned, the victim calls him in this panic state. He'd just been shot.
That is the night of the offense. It is not anything to do while he has been on bond. If he wants to ask about whether or not and if he has information, which I can certainly ask him on voir dire, if Zachary has been near the victim during the bond, then that is relevant. Otherwise, this is not relevant.
Well, Judge, in addition to his past criminal history, which we've already covered, and this testimony right now, it shows a propensity for violence. That's relevant.
The serious nature of the offense is, that's it. Is he a flight risk? We're here about a bond. We're not here about the trial. We're not there yet. We will be, but we're not there yet.
Whether he's a danger to the community is also relevant, not just flight risk and
The
serious
offenses
nature.
speak for themselves.
Well, Mr. Cook, you've already elicited from Mr. Spurlock the nature of the offense. Is there additional information you need from Mr. Spurlock?
Required information? No, I don't believe so, Judge. So I'll pass the witness.
I have no questions.
Thank you so much, Mr. Spurlock. You may be excused.
Thank you, sir.
Okay. Thank you.
Mr. Cook, you may call your next witness.
Stay rest, Judge.
All right, Ms. Hathaway, would you like to make a closing statement?
I would, Your Honor. My client has the right to a reasonable bond. The Eighth Amendment ensures that. Not only has he paid a bond, not only has he paid $250 a month to be monitored, but now he's put unreasonable restrictions. My argument is not letting him go to eat, not letting him go to the grocery store, not letting him go get his mail. That is not reasonable. We set bonds and we put bonds in place to ensure that they are going to return. If he is not found to be a flight risk, then these additional conditions that are imposed quite often in these counties are not reasonable. My client has a right to a reasonable bond, and that has not been the case yet. We are asking that his bond reinstated in the monetary amount without an ankle monitor.
Mr. Cook?
Yes, Judge. The state is going to oppose any setting of a bond in this case, given the serious nature of these offenses. We believe that he's a danger to the community and a danger to the victim. First of all, the defendant is charged with a litany of offenses, all of which, except for a state jail felony, are all felonies. So he's got almost a full house. He's got a first degree, a second degree, a third degree. Furthermore, the alleged crime is that he shot another person. His bond conditions are reasonable. Being on a GPS monitor, that ensures that we know where he is because he is a danger and a threat to this community, as the state is alleging he has proved before. Furthermore, his criminal history shows that he's got assaultive behavior. So we see a pattern here with this individual. The state is asking that no bond be set in this case and that we get to trial on this case holding him in confinement. That way we can protect the community. It's not just a simple calculation of whether or not he's a flight risk. He's got a job here, he's got work, I understand that. But at the same time, we're trying to protect the community by keeping him confined. And given his past history, I mean, there's nothing to show that all of a sudden he's just become a peaceful person. Furthermore, with respect to the groceries and things like that, he stated he's got friends that can help him out with that. His boss will stated he'll help him out with that. He has no reason to be going to a grocery store. That'll only further embolden him to either hang out at the grocery store or go to places where this court says he's allowed to be and abuse that. He's got 7 violations, all of which have been reported by the emergency management team. They prescribe to what's in the court order. And so anything outside of that is a violation. So he's violated. They've made claims that they allowed them to do this, they allowed them to do that. There's no proof of that. There's absolutely no proof of that other than what these 2 individuals say, one of which has all of the reason to fabricate and misstate to this court because he's confined. So I don't believe that reinstating the bond is appropriate. However, alternatively, we ask that if the bond is reinstated, that the bond is doubled and that the ankle monitor remains in place. Thank you.
I'll remind the court that for these litany of these 7 violations, they all involve going to get food or gas or his bodily home. Interestingly, when Tommy gets on and testifies and says, well, something was said about arresting, it's not in the court's order. So it's not in the 4 corners of the order if he was asked about by Mr. Cook, and yet he was given permission to go there. So it doesn't make sense to say, oh, well, you can't go eat, you can't go get groceries, you can't go get your mail. It is not reasonable to tell an individual they can't do that. That is not the purpose of a bond. Moreover, it's not the purpose of a bond to monitor a defendant. In fact, it hampers the defense. If I'm going to get him into counseling, if I'm going to get him to do a lie detector, now he's being tracked, and I may or may not be able to defend him effectively. I hate these GPS monitors for that reason. They are nothing but a punishment to a person who has been charged with an offense. And mind you, he has not been found to have committed that offense. Interestingly enough, in all of the argument about how dangerous he is and safety for the community, not one of those violations alleges that he did anything more dangerous than go to flippin' Wendy's. That is it. We're asking that his bond be reinstated without the ankle monitor. There's no reason for an ankle monitor. He can't, because I get the last posting. It's my motion. We don't get to go back and forth. We're done.
I'm going to go ahead and think how to articulate this. Ms. Hathaway is right. The purpose of a bond is, as she stated, and also as Mr. Cook stated, to protect the community. However, there has been no violation of the bond related to or in any way endangering the victim or the community. I do see the need for the GPS monitor just because of the heinousness of the alleged crime. But I don't, I'm not convinced that we need to keep him incarcerated until next year when we have, but by the time we get a trial set on this. So I'm going to set his bond at $100,000 with a GPS monitor.
And he needs to
Yes, but,
Should we allow him to go get food, groceries, gas, mail, mundane, ordinary things?
I'm gonna say not the grocery store. However, yes, I mean, there is no DoorDash in Dalhart. There is no Walmart delivery in Dalhart. So, gas, and let's make clear in the order that the conditions are, he can get gas, he can do drive-through, fast food, and he can go to his boss's house. He can travel to work-related sites. I know,
Mail,
like at the post office.
I know that requires him to go into the post office.
Does he have mail? I mean, some homes have mail delivery at their home.
He's living in an RV right now.
Mr. Cook, do you know?
I don't know, Judge, but I have another comment on if we're gonna allow him to go to these places. I'd like the word to state that he's allowed to be there for a reasonable amount of time to effectuate the purpose of the stop. So if he's there to buy groceries, I want him there to buy groceries and gone. Well, Toot and Totem or, all,
Yes.
right? So not the
He's at a
grocery store.
convenience store or a fast food place or the post office. I mean, since we're talking about this, as long as it's necessary to effectuate the purpose of the business. All right, anything further? All right. Thank you. Let's move on to one of our,
Okay, that's all, Mr. Nelson. I'm sure, Ms. Hathaway will be visiting with you shortly, okay?